that, yeah, we could, yeah. I see, that's it.
Is that gonna be in the middle of the?
Yeah, they're automatically in.
And we're gonna have all this before.
Okay. Ronnie, can you hear us?
I can. Can you hear me?
So, 6 o'clock, this is the meeting, the legal committee meeting. Ronnie, we're gonna wait a couple of minutes, for Crystal to join. I don't see her yet. In the room here, it's myself and Dominic. Jenny is on vacation.
I don't know. Yeah. we're going for
Oh, Crystal just joined. Crystal, can you hear us?
it.
I can. I'm gonna go on video through my computer as well. It just I'm having some technical difficulties.
Okay, we'll wait. Okay, we can see you. Great. Okay, so we have two items on the agenda this evening. One is the short-term rental issue that I brought up in the last meeting. Second is the new business from last meeting, which is good cause eviction law. So I'm going to begin very briefly, Dominic, with the short-term rental.
Sure.
Because there really isn't anything more for us to do on that right now. We need to get more information about the registry. We need to get more information about the inventory from Michelle to figure out how we could use the state registry for enforcement of short-term rental and so forth. So I'd like to kind of put that off, Ronnie as well, put that off for our discussion at our next meeting and gather more information on the registry data that we'd be able to get from the state. So that leaves us with the good cause. Any questions on that, Ronnie?
No, that sounds good. Thank you.
So that brings us to short-term rent, not short-term rental, to good cause eviction. So I had assembled, and Dominic also put materials together. We have the 6 municipalities that have passed it. So we distributed the documentation for those 6 municipalities. We have Crystal's summary of the law. I also posted the law itself. We received a number of communications from residents and interested parties relating to it. They were also posted. And Dominic provided a link to a informational website that came out of New York City that provides in very clear language an approach, an interpretation of what the law actually means. So I think probably our best bet here would be, Crystal, to begin with an overview, if you want to give us an overview of the law itself, and then we can talk through whatever issues we have. There are a number of people from the public online. We also have some people in the room. I want to make sure that everybody has an opportunity to, we go through and we discuss this, that there is an opportunity for the public to share their thoughts. So we'll make sure that happens. So, Crystal, do you want to begin with your overview, and Logan, you could just pull up the overview. Oh, I forgot to do attendance. It's me, Dominic, and Ronnie. Go ahead.
Okay. So can you hear me okay? Okay, good. Okay. So as everyone is aware, in April, New York State adopted its own good cause eviction law, and that this law automatically applies to New York City, but it also allows for municipalities outside of New York City to opt into it. If those municipalities do opt into it, then the entire law as set out by the state statute would be adopted, and there can be 2 changes made. But generally speaking, what this does is it makes it so that tenants are protected from unreasonable rent increases. And that portion, as to who, as to what that rent's going to be, can be set by the local governments. So essentially, the law automatically provides a default for rent over 245% of the fair market price. It exempts them because it's considered luxury housing. That amount, that 245%, that can be changed by the local municipalities, and you are seeing that. So with the laws that I had provided examples of, such as City of Albany, Ithaca, Poughkeepsie, Kingston, and Beacon, they've all set percentages of the fair market value to be above that, ranging from 300% to 345%. The main part, there's a lot of background. There's something going on back there, isn't there?
No,
You're completely quiet.
Oh,
No,
really?
there's-
Because there's something that I'm hearing.
we can hear you.
Okay.
Sorry,
So-
Crystal, before you go on, the two things that can be changed, that percent of market, but the other thing that can be changed is the number of units. The definition of a small landlord in New York City is 10 or more, whereas the 6 examples that were provided with the other municipalities, that number can also be changed by local municipalities, and the others that we have examples of have set that number to 1 or more, and that's within the state of New York.
Yes. So all of the cities that have adopted this so far have adopted it, changed the definition of a small landlord to be someone who just owns 1 rental unit in New York State. My understanding is that the reason for setting it at 1 is so that the net for this law is actually much wider than what would automatically be defaulted under the state statute, which is the 10 units. Now, what this law does is it provides tenants with protections, again, against unreasonable rent increases, from being evicted for no cause at all. So the landlord actually has to show that either they're not paying their rent, that the tenant has, become a nuisance, that they are not allowing access for the landlord to get into the property to make repairs, things of that nature, that there's a substantial and material breach of a lease agreement. It also provides protections for lease renewals. So a landlord cannot decide anymore to just simply not renew the lease because they do not like the personality of their tenant. They can't do that unless they have good cause. And it also protects any sort of tenancy that is month to month. And I think that's a pretty significant change, because so far, if you're a month to month tenant, the landlord only has to give you 30 days notice, and then you can be evicted from the property. That is no longer the case. They are going to have to show good cause for that. So that's a very general overview of what the law is. There's probably a lot of specific questions that'll come up. There are several exemptions that are automatically written into the law that the city cannot amend or alter in any way. So for example, any sort of housing that had a CO, certificate of occupancy, or a temporary certificate of occupancy that was issued after 2009, they are exempted from good cause eviction law, and that exemption lasts for 30 years from the date the CO was issued. So for example, if a CO was issued in 2009, they get that exemption until 2039. Other exemptions are owner-occupied housing with no more than 10 units, co-ops and condos, where the unit is rented as part of an employment agreement. Any sort of rent stabilized or government subsidized housing is also exempted. Seasonal use dwelling units are exempted. Transient housing, such as hotels, bed and breakfasts, those types of things, are excluded, along with school dormitories and religious housing and facilities. So that's a general overview of what the law encompasses.
So I have a couple of issues that I want to raise. I don't know, Dominic, do you want to start or do you want me to?
So I just got a couple questions,
Yeah.
Christopher. So one is the LLC. My understanding is with the LLC situation, if somebody wants to claim they're not eligible as a landlord or LLC, they have to then disclose the ownership of that building, correct?
Yeah, because you're looking at beneficial owners. So a member of an LLC would be considered a beneficial owner. That would have to be disclosed. There's also been, this isn't necessarily so new to the good cause eviction law. There has been changes in some of the LLC requirements for real property where there has to be a disclosure of the individuals that are the beneficial owners of the LLCs. But yes, that is part of this law.
So also, so say for example, I have a house and I rent out a room. And if we then change it to one, right? Does that then make that room eligible for a good cause eviction?
I don't believe so, Dominic. I think if I recall correctly, and I looked at this when I had initially started digging into this in August, in the beginning of August, where if you're renting out just one room in a house, as opposed to renting out an actual like dwelling unit, like the full house, that the good cause eviction would not necessarily apply, but I'll double check that.
Crystal, I had also seen that a rental unit in a building, it's the only unit in the building where the owner is the occupier. Those are not eligible for this law. They are exempt.
They are exempt if it's an owner occupied housing with no more than 10 units. So if you start going into like the bigger apartment buildings and there's more than 10 units, they lose that exemption.
Right, but in a scenario with less than 10 units in a building, if it's owner occupied, the law exempts those properties from this law.
Yes, that's correct.
In a scenario, even if you have a home where you had a separate rental unit in your home, that would be exempt from this law because it's in an owner occupied building.
Right.
So that would not be covered.
Yeah, yes, thank you. Yes, thank you. That's absolutely true. Yes.
I think that's what I have right now. Thank you, Kristen.
Yeah, any other questions? Yeah, so a couple of things that I know just been reading the law. So first of all, I'm coming at this from the perspective, I'm not a landlord, I've never been a landlord, but I have been a tenant for over 25 years. And I am concerned about a couple of unintended consequences that could arise from this law, and particularly if we set the threshold at one. One item is the non-renewal piece. So you have a situation where the landlord is essentially entering into an agreement with a tenant where he or she no longer has any control over the decision not to renew unless there is good cause not to renew. So one of the good causes for non-renewal is that you're taking the property or the unit out of the rental market. So that's one of the options. So one potential negative that I see for tenants on this is that a landlord entering into an agreement where there is no date beyond which they can say, okay, we're not renewing this contract, they are going to be much more careful and vetting future tenants. So someone trying to get into an apartment, I think this law will create hurdles for them. It will create a situation where you won't want to take a risk on someone. You will want good references. You will want very good credit scores. And I personally, as a tenant, would see this as something that would potentially make it more difficult for me to get an apartment. The other piece to this is with the threshold on the rent raises are reasonable, and it allows for increases if you can document that there's some reason for that. But if you have a situation where you have a unit that has not been rented at a particularly high rate, and you know that you're entering into what can be an indefinite length of time with the tenant, you're going to start out potentially with the highest rate that you can get for that apartment. So the other unintended consequence might be an actual increase in the rents for new apartments for people trying to get into a new rental. And the other item that I noticed when I was going through it, Crystal, and I believe this is the case, one of the good cause reasons is that you're taking it off the market, but it does not say anything in the law about the length of time it needs to be off the market. Are you taking it off the market permanently? Are you reselling it? Are you taking it off the market for 6 months? So if you want to get rid of a tenant, you could take it off the market. You could let it sit there for 6 months, and then you could bring it back on the market at a much higher rate if you were trying to gouge. So I have concerns that I think that this law, I believe it was trying to protect tenants from rent gouging. And I think that some of the other things that have gone into it could potentially have a negative impact down the road on the tenants. Because it doesn't just focus on, let the landlord have the right at the end of the contract term to say, don't want to renew this, that's fine, give enough notice. But do not allow the rent on that unit to increase even with a new tenant to a rate beyond what is reasonable. So I think if it had focused more on that, it would probably be more protective of tenants than the way it's currently written. So those are some of the concerns that I have. Ronnie, do you want to comment on any of that, or do you have any questions or concerns that you want to raise, Crystal?
Yeah, thanks, Margaret. Can you hear me?
Yeah.
Yeah. I'm glad you brought that up. My concern was also regarding the open-endedness of lease renewals. It leaves it up to the tenant. I think it spells it out when you can evict a person for, if they're bad tenants as defined by the law. I mean, as Crystal mentioned, if you don't like their personality, that should never be a cause for anybody's eviction. But it still leaves some questions regarding what are the unintended consequences that can arise. And I think you really hit the nail on the head about describing some of the potential issues. And the one thing that I also was thinking about is that the law provides some provisions and sets maximums for what rent increases can be. It doesn't. The one thing I thought that was a little odd is that there's no provisions that spells out, for example, if the municipality decides to raise rents or raise property taxes. Because generally speaking, landlords will pass that along to a tenant if there are increases, because that increases their costs and that gets passed on. And now in the future, if for some reason, I'm sure the city also has to abide by certain caps on that. And I think Crystal can speak on that. Maybe the city also is bound by the same limitations, and that's why it doesn't need to be spelled out. I think that's something Crystal could clarify for me. That would be nice.
It's not that it's not spelled out. You're right. It's not spelled out in the law, but what the law does allow for is it allows for reasonable increases. And that means increases that actually can go above that 8.5, 8.8%. And this is going to be a matter that's going to end up being litigated in the courts, because what is opined now by a lot of individuals and law firms and agencies that are going through this law is that reasonable expenses, such as, if the property required some significant repairs, capital improvements, or if there was an increase in property taxes, that would all be a basis for a more significant rental increase. But what's going to end up happening with that is that it's going to end up being litigated where you're going to start seeing court decisions that are come in and they're going to say, okay, this we're going to consider reasonable, this we're not going to consider reasonable. So that's how that's all going to end up being defined as this legislation moves forward.
So Ronnie, one other thought that I had, this comes back to setting the number at 1. And I think, Dominic, you raised the issue when we talked about it last time. We got some information from Michelle. I think we really need to understand the landscape of the rental market in Hudson. and how many properties we have that are owned, that are maybe the person only has 1 or 2 units, as opposed to somebody who has 20 units. Because one thing I would foresee there is if being a landlord is not your main source of income, but you have, say, an investment property or whatever, and you're renting it out, that you might choose, given this scenario, and not wanting to be put in a situation where you have no control over ending a lease, you might make the decision to simply get out of the real estate market or the rental market. So the other, unexpected consequence here could very well be a reduction in the number of available rental units in the city for those small
Yeah,
landlords with very small numbers. Go on,
yeah, I
Ryan.
think, yeah, that brings up an interesting point too. For example, if somebody does, let's say they don't want to deal with this, this new law, and it makes it extra difficult for that single person. What if these properties are sold to, let's say, a developer who updates them and then increases the rent to 345% to get out of that threshold? Now they're no longer even in the realm of being affordable, but at the same time, I mean, I don't think it's really up to us to really think about all these like potential ways that people can work around the law. I think you're right in that we do have to kind of decide on how it will affect Hudson rather than
Right.
as it stands. Not something we should decide right away. We need to really dig into the numbers before we make that decision.
Crystal, so well, you said that obviously you're gonna have to, litigate some of this. Now, with the threshold of legal aid, if someone is not qualified for legal aid, that means that person will have to foot the bill for an attorney on their own to fight this.
So possibly, yes. There are a lot of individuals that fight housing cases actually on their own, either at the city court, the city court levels, or at the housing court levels if you're down in New York City. The statute itself, though, it does provide some guidance. So the statute itself goes through and talks about, well, what is going to be an unreasonable or reasonable basis for an increase? And it does specifically reference, landlord's costs for fuel or other utilities, insurance and maintenance, property tax increases. Those are all things that courts are to consider when you're looking at reasonableness, as well as the repairs, to make sure that those repairs were not caused by the landlord's ignoring, his maintenance obligations, but significant repairs that come up as they naturally do with owning property. So yes, in some respects, it's going to require tenants to go ahead and get attorneys if they want to fight it. At other levels, tenants are going to be able to go in and they're going to be fighting these like they would eviction cases at the city court levels. That's all going to depend on the jurisdiction and what programs are available.
Thank you.
So, Crystal, my reading was that if a landlord wants to increase the rent by more than the defined reasonableness, it's on the landlord to submit all of that material to the court, correct?
It would be, yes. So what I envision will likely happen here in some of these cases, because that would be a basis for a tenant to withhold rent, at which point you'd have the landlord likely bringing that tenant to court to either evict them and do a non-payment proceeding. So what I would expect, what you'll see how these will come up, is that you'll see a rent hike and the tenant either just paying what was the regular base rent or withholding rent altogether, and then the landlord bringing them to court, and then that dispute playing out.
Okay.
So Crystal, if a tenant is receiving Section 8 on their rental, does that exclude them because that's a subsidy? Does that make that apartment ineligible if they're receiving Section 8?
So federally subsidized housing is exempted. The only thing I started to take a look into, and I was trying to see if I could get a solid answer on, is whether the Section 8 vouchers essentially fall into that. I do think they do because that's considered federal subsidy for the housing, but I just need to look at it a little bit further. I don't know exact off the top of my head.
And a fairly common scenario is a situation where if you have mixed income, I don't know if we have this here, where you have mixed income and a certain percentage of units are at below market and they're available for Section 8 versus others that are at market value. So that would apply more to like larger complexes where you have mixed market and below market rents. So I think since this is done at a unit level, Crystal, I think that the units that are linked in any way to income are exempt, and then the other units are not.
I would agree with that. So for example, the proposal that the Common Council was looking at, I think maybe it was last year with Hudson Dots, that regulatory agreement with Hudson Dots for affordable housing, any of the units that fell within that would be exempted from this.
Exactly. And so the other thing from rounding to your point about what difference is making Hudson, the other thing for us to remember, and this is why I think we need to get more detail on the landscape, is that we have anything built after 2009 or undergone major rehab since 2009, those things are exempt. And so a lot of the housing that we have currently coming online, or the housing, the Galvin housing on Union Street that recently became occupied after being vacant for a long time, that underwent significant rehab for that building to be able to be open again. So properties like that will be exempt. I think we need to get our arms around how many of those there are and how many, what exactly would this apply to? And then what is the structure, the landlord unit structure? So we have a good approach to setting that number of, your reasonable number of units to define a small landlord. Because we don't want to have a situation where somebody who just has one, 2-family house or something that they're renting decides to just take it out of the rental market altogether rather than deal with this. That would not be a good outcome.
So Crystal, this actually creates two loopholes for the landlord, because right now, landlord loophole around Section 8 is they make the rent threshold higher for Section 8. Now, there's another loophole. They said, okay, we're going to set Section 8 to get out of their eligibility status of this law, correct?
Sorry, can you explain that to me, Dominic? I don't understand. I don't understand what you just said.
So right now, a landlord, if they set their,
I'm sorry, can we, because it's hard enough for Crystal to hear. Go ahead.
so right now, one of the loopholes to get a landlord uses, right, is to do the rental, the threshold higher than what Section 8 allows. So that then some people Section 8 can't rent that apartment.
Gotcha.
This then turns it the other way around, says we're going to accept Section 8 because you now then are not eligible for good, even though the apartment might be.
Yeah.
But you then, by receiving Section 8, are not eligible to be in good cause eviction because you're receiving. So I see this as somehow another landlord loophole in one regard.
You have a
Well,
comment on that?
what's being accepted is your luxury housing at the high end and your affordable low income housing at the low end. So it's supposed to, what this is designed to capture is everything in the middle, that where you're not going to qualify for low income and affordable, or it's not subject to an affordable housing regulatory agreement, and it's not luxury. This is the middle. This is what this is capturing.
So I don't see any hands raised. I think, Tom, you had your hand raised a moment ago. Does anyone,
The scenario.
sorry, anyone on the committee have anything else they want to say? I want to start getting questions from people in the room and from other council members. Okay, go ahead.
I didn't understand your scenario of a family house where someone just decides not to rent the other half of it. What would they do with it? Just leave it empty? That doesn't make any sense.
No, I'm talking about a situation where if you just have one property that you're renting, it's not your livelihood, and you don't want to contend with this. You have a couple of things that I could see happening. getting out of the landlord business and simply selling the house,
So,
taking your investment,
Okay.
and then it goes out of the rental market. That's an option. Another option is that you might decide to let it sit for 6 months so that you can then bring it back on the market at twice the rental rate. That's what you want to do. So I can think of a couple of scenarios where, particularly with very small landlords, they may choose to walk away from the market or set themselves up to be exempt in some fashion. That's sort of saying. The point about if you have a property, if you have a two-family home and you're renting half of it, those properties are exempt. They're not part of the stuff.
okay.
So basically, you sell your house, whoever comes in, because now that tenant's gone, whoever comes in can raise that rent until,
Well, they can
to
do
that
that.
threshold because it's new.
They could do whatever they like. They could choose not to, they may not want to be landlords at all. They may
Right.
just want to purchase the house and take it off the market.
Right.
So, I mean, I think we need to, yeah, go
You
ahead.
can already do that. I don't really.
No, well, no, the problem, Tom, is that because this puts in place this, lease in perpetuity where the landlord no longer has any control over that. That puts in a situation where, for a very small landlord, that may be the thing that says, I'm going to get out of this. And one of the good causes for terminating a lease or non-renewal is that you're taking the house or property out of the rental market.
But I
Yes,
think there's something in the law, though, Margaret. I think there's something, if that tenant then has a case, if they prove that, right, Crystal?
So yeah, there's a good faith requirement there. So in order for that to work, where a landlord decides, you know what, I'm just going to take this off the market, and they're doing it as a way to circumvent the law, they have to show by clear and convincing evidence that they took that off the housing market in good faith, not to circumvent the law. So there is a standard written into the statute for that.
We have a hand raised online, Logan.
Yeah.
Enrico Perita, I think.
Yes, thank you. Can you hear
Sorry, if you could just identify yourself and your connection to Hudson.
Yes,
Margaret, before Enrico, Vicky's had her hand up for a while. Should we let her go
I'm
first?
sorry.
Vicky had her hand.
Oh, I'm sorry. Sorry, Enrico. Can you hold a moment? Vicky has
should
her
not
hand
be
up.
participating.
Excuse me?
Vicky should recuse herself. I don't know why she's participating.
Vicky,
She's a landlord. She is.
we're not voting on anything.
I know, but it doesn't matter. She shouldn't be part of the conversation. Vicky knows that.
I see no reason not to allow.
No,
Hey,
no.
Tom,
Yeah.
I can make a comment, and
Not really.
it doesn't have to be excuse me, Tom, it doesn't have to be a partial comment. I can just, why, we're not allowed to talk here?
Well, if you
Are
want
you
to.
serious? Are you serious now?
Sorry,
That's not
Vicky,
about, how do you know what I'm gonna say?
Vicky, can you hold a moment? Can you hold a moment, please? Hold a moment. Vicky is not a member of this committee. Just a moment, Tom. Vicky is not a member of this committee. She is not speaking as a member of this committee. She is a member of the Common Council. I agree with you in the Common Council. If she's recusing, that's fine. But she is not a member of this committee. And Crystal, I'm going to toss this over to you. Do you see any reason why Vicky should not be allowed to speak?
So this is complicated because Vicky is on the Common Council. I understand that she's not a part of the committee. Technically, if you are recusing for a conflict of interest situation, you are supposed to refrain from participating in the discussions. Those typically occur at the Common Council level. I would, if she is recusing legitimately for a conflict of interest reason, I would be hesitant to have her participate in any discussions that could be a basis for the Common Council's decision.
Okay, so the recusal reason is that Vicky is a landlord.
Yes, yeah, Vicky had discussed to me that she has a conflict of interest on this. If she's a landlord, it's going to be based on I'm assuming, you know, the fact that it's going to affect her directly and that she may have a financial impact from it.
So by the
No,
same
it-
token, Vicky, I'll come back to you in a second. While we're talking about recusal, by the same token, I think any member of the council who is a tenant might also need to recuse themselves because they also have an interest in the outcome of the decision.
Is that true, Crystal?
We're getting into the weeds. All right, so here's the thing. I would like to take a deeper look at this. I can't say, no, I can't say that that would be, if you're going to have everyone who's a tenant and a landlord recuse, I guess the question I would have is, do you have enough left at a quorum to be able to vote? And I would honestly need to take a deeper dive into all of that. For committee purposes, and I'll do that before we get to a council meeting on any of this. For committee purposes, I would say that if, you know, speaking right now, because of this issue's up in the air, then I would say anyone would be able to speak. And then I'll have a determination for everyone before we get to a council meeting. But yeah, you're right. If you're looking at it from a landlord viewpoint, then you're also going to be looking at it from a tenant viewpoint.
So Vicky, are you okay with that, with Crystal's comment there? Do you want to wait until she has an opinion on this?
Yeah, I have no problem with that. And by the
Okay.
way, Tom, you are absolutely wrong. I wasn't planning to say something against your law that you love so much. It wasn't that. I was planning to say something that it was really my opinion of the tough legal matter, and I really think that the committee is doing a great job and whatever. But you know, I really don't like how you cut off women and how you cut me off all the time. I don't.
Crystal, Crystal, when you,
That's actually my job.
sorry, Tom,
Chair.
this is not your meeting.
No, it's true.
Crystal, when you're looking into this, can you also look into whether or not, I mean, certainly it's Vicky's prerogative to choose to recuse and speaks to her integrity, but could you also look into whether or not you would consider it necessary for somebody who's a landlord to recuse?
I will take a look at all of it.
Thank you very much. So, sorry, Enrico, we're going to come back to you now. You are muted. And just let us know what your relationship is to Hudson.
Yes, good evening, everyone. My name is Enrico. Been renting in the city of the Hudson for the past year. I'm an attorney myself. So, you know, looking at this from the perspective of someone who did just look for apartments in the city of Hudson, regarding rent, rent is already above market rate for most units. I've already seen many of the houses on my street, on Columbia Street, are not occupied for the majority of the year. These are people who are not living in the community. They're not contributing. They're not buying from local businesses. And that also fits the description of my landlord as well. It's a two-family house. And what I would say about that in terms of those types of landlords getting out of the market, I don't think that they should be in the market in the first place. Those rentals are not good for the community. They're not managed. These are absentee landlords. They rely on property management companies that are often also absentee. They shift liability from the LLC to the property management company, to the third-party vendors who make the repairs. So these are people who should not be in the business. And if they are going to be in the business, they should be in the business of multifamily units, which is what Hudson actually needs, is more housing, more multifamily housing. But they should not be renting one or two unit homes. These are homes that should be mom and pop landlords, small landlords, or they should be full-time homeowners, right? So if those people that you're talking about are going to sell that house, hopefully they don't sell it. Hopefully they sell it to someone else who's not them, right? Because they shouldn't be owning it in the first place. And that's a problem with a large amount of rental units, is just bought up by money in the city. It's money that leaves Hudson. It's not helping the community in any way to have any of this money flowing out of the city, flowing into Brooklyn or Ohio, or to enrich the coffers of people on Wall Street. I mean, those are the types of people who are buying these houses. They're not mom and pop landlords. And so that's why it really should be 1 unit at most. I tend to think there really even shouldn't be that cap whatsoever. And so regardless though, beyond that, you know, these landlords are not going to go to the effort of initiating eviction proceedings, which they would have to do. They have to do that now. They're not going to go to that effort, right? They may try and evict tenants unlawfully, but they're not going to go to the effort to get a court order. You know, if they're absentee landlords to begin with. So ultimately, it's not going to affect them. They're already charging enough for rent. They're not going to look at it as a loss. Many of them bought these houses in cash, so whatever they're getting in rent is enough for them, and they view it that way as well. And if they do sell it again, I don't think that's a bad thing. I think that's actually a win for the community because Hudson needs more full-time tenants. And I did want to address one more thing, and I apologize. I know I've been talking for a bit, but I want to address one more issue. You know, I was at the last Common Council meeting, and I believe it was Dominic, I think, that in reference the same thing here as well about needing an attorney, tenants needing an attorney to kind of enforce the law. And what, you know, I would say that this is, again, not a change from how it is currently. I mean, obviously, for any sort of impact litigation that would affect the law, these are going to be landlord initiated or legal aid initiated. But tenants shouldn't need attorneys if landlords are following the law, right? So a landlord should, if they want to evict someone under good cause eviction, still needs a court order in order to do it. So they have to go to court. So it's kind of the same thing as any other eviction proceeding. They're still going to have to go to court. Tenants, if they're eligible for legal aid, can get an attorney. If they're not eligible, then it's the same situation as currently, except they will actually have more protections and they will have more ammo on their side to fight the eviction. So I don't really see that as being a particularity of this law, because ideally landlords should be following the law, right? You know, the law gets passed, landlords have to follow it. It's like any other part of the housing code. What I would suggest, I think, is that perhaps Hudson look into some enforcement mechanism. You know, I think something like making this part of code enforcement's job potentially, or the housing officer. I think those are possibilities that, you know, it could sidestep the need for having to have everything go through court. I mean, a lot of things can just be solved through mediation, potentially facilitated by the city. So thank you for the time.
Okay. I just want to make a note that I think I said at the beginning, we did receive correspondence from multiple people, and all of that correspondence has been posted to the folder for this meeting. I received 2 emails late in the afternoon today, which will be posted by tomorrow. So if you want to see any communications from community members, they're all posted.
I got something real quick.
Yeah.
Just to respond to Rico real quick. You know, I've seen, you know, been involved in eviction cases for my clients, and bad landlords are bad landlords, and they're going to push that envelope to force you to get an attorney. Or I've seen bad landlords get away with stuff that's on the books now. So, you know, my concern is that, you know, if this law gets too drawn out or too deep, that, you know, they don't get the proper legal representation if they have to depend on themselves, right? So that's why I want to make sure that this, you know, we have fair legal representation to fight this law if they need to in court for the landlords. I mean, I get what you're saying. You know, right now that sometimes the eviction, you can do it on your own, but now I think it's going to get even deeper. And I just think that there's going to be needs for attorneys.
We have a comment in the room, Tom.
Yes, Dominic, I don't quite understand the logic though. You're saying because someone's gonna need an attorney to challenge a landlord, we shouldn't have the law?
No. I just want, no, you got to understand that. No, I'm just saying people got to understand they're going to have attorneys, right? And legal aid is booked up now as it is.
Right.
This is going to really, you know, force, you know, some decisions, you know, that you might have to make. So saying, I'm not going to fight this because I have to pay out of pocket to fight this. You might not fight your landlord.
So you're saying we shouldn't have the law? Because
No.
someone can't.
I'm just making
I
it
understand
aware.
what you're saying.
I'm just making people aware that, attorneys are gonna be needed in this law, right? So that needs to be in consideration. I'm not saying yay or nay about passing it.
Just trying to understand.
I'm just making people aware how deep this law gets and can get, especially with bad venues.
So Ronnie, and I don't see any other hands raised. Oh, wait, hang on, we do. Second row, I think you had your hand up first, yeah. Yeah, if you could identify yourself.
My name is William Galvin, and I'm a local attorney who represents, part of my practice is representing the indigent, many of whom live in Hudson.
Okay.
First of all, I have a question for Attorney Kathy. My question for her first is, of the 6 jurisdictions, I guess that would include New York City, that have passed good cause eviction, how long has good cause eviction been in effect? And have any of the effects that people talk about happened? Have been people taking the law?
Well, I can tell you that most of them have been in effect for like less than a month because the law is very recent. And no, there is not sufficient information to know because not enough time has passed to see what effect it will have.
Okay.
But Crystal, I don't know if you want to add to them. If you look at the.
No,
six
yeah,
statutes-
the state statute was adopted. The state statute was only adopted in April of this year. And most, like, for example, City of Beacon only adopted their law in August. Most of these other laws were adopted in July, between July and August. So there's not enough time to truly evaluate that.
I know every document has a date on it. Every law passed has a date. We had another hand raised, yes, name and.
Lucky Forbes, and I really appreciate all the issues that you brought up around what could possibly happen if good cause eviction was to be passed in Hudson. And I can tell you right now, landlords are raising the rents as soon as they have an open apartment. I can tell you right now, as a person who has looked for properties, credit scores are already being scrutinized. They're already looking for references. As someone who has a felony, it is extremely hard to already get an apartment. And even the fact of landlords possibly taking their properties off of the market for a while and bringing that back in. This was something that Crystal pointed out was something that actually is also protected within the clause. As far as landlords taking tenants to court with or without a lawyer, using legal aid, going to court themselves. These are all decisions that are currently being made right now without good cause eviction. The one thing that would change with good cause eviction, though, is that you cannot unnecessarily up your rent without a good cause. That you cannot evict anyone without them breaking the lease or not paying rent. And if a tenant was to withhold rent, regardless if you have a legal aid lawyer, if you represent yourself, or if you were to hire a lawyer, and you was to go to court as you do right now, you would still be able to prove that if you were raised in taxes or property tax, that you had a valid reason to raise your rent. And as a tenant who can't normally afford lawyers, you would now have way more protections, not having a lawyer going into the courts with good cause eviction. The one thing that I appreciate the state government for doing was passing good cause eviction. I, as a resident of New York State, am baffled and really just like also speaking on behalf of an organization fighting for tenant rights. For those that have municipalities opt in is a low blow, let alone. This conversation right now is not fully taking into consideration the fact that tenants are not protected under these rent hikes. Tenants are not protected from landlords who we all know are out here that are dangerous. They're predatory landlords. There are no protections for tenants currently. Good cause evictions with the things that have been highlighted in front of this council right now as problems are not problems that would exist because of good cause. Those are problems that exist right now that will not change without something like good cause actually supporting tenants. all the issues that have been pointed out have been already called out to be things that are not actually issues and are protected under the current clause currently, and are issues that are currently going on. And I appreciate you bringing that up, because that speaks to more work that we have to do to make sure that landlords cannot just deny people the access to housing. That is what I'm hearing. People are being denied access to housing, and that will continue to happen, regardless if we pass the clause eviction or not. The only difference is people will be able to stay in their apartments and not have to be kicked out because the landlord changes their mind down the line.
Great, thank you. Any other comments? Okay, yep, name and,
Crystal Hines, Fifth Ward resident. I'm also a landlord. I have 2 units on mine at the moment. I have 8 more that are in renovation process. I have to say, I'm a landlord. Rental properties. Those of us that take a chance on people that don't always have the best credit score or the best work history, we won't do that anymore, because it's going to be too much of a risk that you could be stuck with somebody that's paying a rent. I'll give you that, but may not be a great tenant for other reasons, may not be breaching the lease. But there are those of us that don't want a lifetime relationship with somebody in our properties. So I understand the intent behind the law. I understand, how vulnerable tenants feel. I've been a tenant myself here in Hudson for 15 years. I understand both sides of the table, but I don't think that this legislation is going to have the impact that it wants. I don't think it's going to provide those protections for tenants. Instead, I think that those of us that do rent to people are just going to be extra careful about who we bring into our buildings. We're going to look for people that are probably going to buy a house in a year or two, so that we don't have that for a relationship. I mean, it takes away a big part of the contract process, which, again, could be favorable in some ways to the tenants, but not so much to the landlords. And at the end of the day, the landlords are making a decision as to who's going to be renting their properties.
thank you. Do we have any other comments from public? Yes.
Hi everyone, I'm Robin with the grassroots organization for the many work on housing justice issues throughout the Hudson Valley.
I'm sorry, could you repeat your name?
I'm Robin Ronda,
Okay.
BRAHVANRANGA. Yeah, I just want to clear up a few misconceptions that might exist around the legislation. Number one, there's absolutely no evidence that good cause eviction reduces the housing stock. That's not been the case in the cities that have already passed good cause eviction. The law in Kingston's been on the books for several months now. In New York City, there's no evidence of that happening as well. State of New Jersey's had good cause eviction for several years now. There's actually research that shows that they're outpacing New York in terms of the development of new housing and the expansion of the housing stock. There's research on that, so I could be sure to send that around. Number two, the idea that good cause eviction would be punitive to small landlords isn't the case. Owner occupied buildings are already exempt, and there's that portfolio size exemption that exists as well. And
Sorry, just a moment. The portfolio exemption of 10 applies to New York City. All of the municipalities outside of New York City that have adopted it have used a portfolio size of 1.
Exactly. Yeah, that's what I get.
Yeah.
So the portfolio size exemption exists. We would recommend that the city sets one at 1 unit. So if you own a rental property and just one, you'll be exempt, or that rental property will be exempt. And the reason the portfolio size exemption is so important to reduce all the way to 1 is that it doesn't exist. There's a potential LLC loophole that corporate landlords can exploit by creating multiple LLCs that would make it harder to enforce legislation. Theoretically, there's a registry of LLCs statewide, but because it's so hard to identify who the owner is, what would effectively happen is tenants wouldn't know if, their landlord is covered by a good cause or not. And what would happen is that landlords would exploit that ambiguity. So it's really important to create an LLC or create a portfolio size exemption of 1 to both cover as many tenants as possible, given all the other exemptions the law has, and to prevent that potential loophole. And also, this law doesn't prevent landlords from making a profit, right? There are justifiable reasons to increase rents due to market forces or, property taxes. So landlords can still raise rents. All it would do is protect against the kinds of unjust rent increases that are effectively the same as an eviction. It would protect tenants against unfair evictions, and would give them that sense of security in their homes. I completely agree that legal services are are deeply overburdened, but the fact that we don't have the necessary legal services doesn't mean that we shouldn't expand necessary rights for the people that live in the city. And we also support, expanding funding for those legal services and a right to counsel for upstate tenants. And I guess the last point I make is, a really important component of good cause is it gives tenants the ability to ask for necessary repairs and those kinds of quality of life concerns, because they won't be afraid that if they make those asks, they'll be evicted from their homes. So, this law isn't meant to be punitive to good landlords. It isn't meant to prevent them from making a profit. All it's meant to do is create an additional level of rights that tenants can then use to feel a sense of security in their homes.
Could you give me the name of your organization again?
Yeah, for the many.
The name of your organization?
For the many.
Okay, thank you.
Thank you.
Much of what you were saying and the protection in terms of, I said that at the beginning, in terms of unfair rent increase and so forth, all of that I think is necessary and good. The one big problem I've got with this is that the landlord no longer has the right or the ability to simply choose not to renew the contract. The contract is between two people. There's a time frame on it, and one of the parties is essentially entering into a contract with no date that they can control in the future. And that to me is problematic. That's my biggest issue.
Can I respond to that or?
Yeah, sure.
Yeah, I mean, I think that, there's like all sorts of like realms. In our economy or our government, not to get too philosophical, where we we do publicly legislate on how people can use their private property and on their contracts, right? Like when it comes to things that are basic necessities, whether it be like food or healthcare or housing, the government and the public has an interest to legislate on the nature of those contracts. And so I think because people have a basic need for housing and because there's a very acute housing crisis, there's a need for the tenant to have a level of rights to continue that contract, because they have if it's not continued, they lose their home, and I think that creates a social cost to the community, not just for the tenant, but because it undermines our communities, it destroys neighborhoods, it creates all sorts of problems that don't just affect that tenant, but the larger community as a whole.
Good discussion. Thank you, everybody. I'm going to turn my hearing aids down here now because I can't hear my, it's too loud for me. So Ronnie and Dominic, what do we want to do in next steps here? Do we want to try to get more data on the land, the lay of the land in terms of properties? Do we want to make a recommendation to the full council to take this up? And if that's the route we want to go, then there's two pieces to that I would suggest that we do. So do you feel that we are ready to recommend that the full council take this up at their next meeting?
Well, I think at this point, we need to figure out what Crystal was talking about, the recusal issues.
Okay, we can, right, but we could still ask the full council to consider this at the next meeting.
Right, absolutely, and see Crystal, what year, landlord renters, if they should recuse themselves from.
And Dominic, just so you know, I did check a quick resource I had here on this issue because it comes up for general legislation as it is. And honestly, recusal on this, as long as it's affecting essentially the entire city or a larger portion than just something specific to a specific council member, then recusal really wouldn't be necessary. What you're looking at are personal or private interests that are being affected by the legislation that is beyond something that is shared in common with the entire city. With that said, if you do have a common council member that is a landlord or is a tenant or will have a financial impact based on the legislation, under our city charter, and just as a matter of proper practice, that does need to be disclosed on the record during deliberations and discussions at the council level. And I will send a short memo out to the full council just discussing that.
Thank you.
Okay, I guess, and again, as long as we, the council, we educate them on what they're voting on and what the two changes they really can do.
Right.
In terms of, but I would like to have more information, even for that discussion,
Do you think
from
that,
Michelle, you know what I mean,
do
to
you
kind
think
of
that we
see.
need more data before it's considered by the full council?
I think we can get it and bring it to the council,
Is
right?
that Michelle Chulo?
Yes.
We're referencing? Oh, because I've been trying to reach her, so she won't respond.
Sorry, can you identify yourself?
Eddie Melendez.
Okay.
Her office is in this building.
Oh, I know where it is.
Okay.
Okay. So, no, my question to you and Ronnie is, for this evening, next steps. Are we recommending now that the council now take this up? Or are we saying we want to keep it in legal for another month and get more data? Ronnie, what are your thoughts on that?
Well, Margaret, as it stands, it's either the city opts into the law, and then the only thing that we can decide on is what do we set the thresholds for the rent at, and then the quantity of units. So those they're not. I think those two things are not really dependent on too much on the data. So I think there's no real reason for us to hold on to it in the legal committee. I think there's not much we can change.
I think there are two separate issues. One is, are we recommending that the full council take this up? And I think Dominic, that you're okay with the data that we got. And the second is, we're not going to make any recommendation on the number of units that the threshold should be set at. I am not in favor of one myself, but that's something for the full council. Do either of you have a recommendation regarding the number of units?
I mean, because there's not a lot of data, right? I think 10 is too high.
Yeah.
But I think 1 is too low, right? So, but if there's somewhere in between, because, and again, I'm wondering, can we change this? I know it sunsets, no matter what happens, we do it sunsets in 10 years, unless the state decides to opt it, right? So, I wouldn't know the benefit of either one. I think 10 is too high because we're talking New York State, right? The whole state, and we're not talking just the city of Hudson. So that's why I think when we go to just 1, right? I don't know, I just think that might be too low.
Dominic, just so you're aware, the council can decide not to opt into this law. So none of it would apply to the city of Hudson.
Correct. So Ronnie, do you have any thought on the threshold issue, or do you think that's something that we just don't have any recommendation on? There's just here tonight, as a committee, we don't have a recommendation specific to the threshold. I don't have a recommendation because I don't know the structure. I don't exactly know how many units are about. But do you think, Ronnie, that we should have a recommendation on the number of units, or leave that to the full council?
I think we should just leave it to the full council, because I can see the logic behind setting it at 1. The person from For the Many gave us pretty good reason why. At the same time, all the other municipalities that have passed the law and set it at 1, those are much larger municipalities with more possibility of people that have multiple,
bigger rentals.
Yeah. So they set it at 1, and I think they have their own reasons to do it. I think we should just let the full council decide. I can't imagine we would be able to find enough data to support 1, 2, 3, whatever.
Yeah, I think it would be difficult actually. So I think for tonight, I think our discussion is pretty much over. I think we got some good information together. I thank the public and those online, present and online, for participating and for sending communications to us. And this is now going to move with all of the documents and communications that we received. It will move to the full council. Are we in agreement?
Yes.
Yeah, I think the best we could do for the council is maybe summarize some of the discussions we've had. That way, you don't have to have the same discussions in the full council.
So is there any new business?
I do.
Yes, go.
Just to put it on a radar, I know we can't do much now, but I think we really need to discuss the floodplain review system through HCDPA with all the new possible development. I think we need to take that out of HCDPA's, because right now I'm the
Oh,
acting
yes,
executive
yes,
director
yes,
just,
yes, yes.
just for
Yes,
that one
Yeah.
case, but moving forward, it's,
We have to do,
it-
yes.
you know,
I
so I
agree.
think we really need to
Yeah.
think hard to put it into code enforcement or put it somewhere else, not in HCDPA's hands with all the new, you know.
So, Crystal, it's fairly simple and we just need to change the code. This is an issue that came up in HCDPA, where I think it's the executive director or something of the HCDPA, which is a position that does not actually exist. Our code requires that anything relating to floodplain review or sign off has to be overseen by the executive director of the HCDPA. And we had this issue come up with the Colarusso project because the planning board, they couldn't move forward with it until this was signed off on by, ordered by HCDPA and then sent to the planning board. And Dominic filled in as an acting director during the period to get this thing done, but the code needs to be updated to move that because there's no good reason for that to reside with HCDPA. So I think it's a thing that you and the lawyer from HCDPA could review, and then we could.
Probably Andy too,
Sorry?
Probably Andy Howard, probably.
Yes,
Yeah,
exactly.
right. Because there's a lot of development around the corner.
Yes,
and-
right.
And this, this came, at the last minute with the planning
Yes,
board, so
that's
we're gonna get in front of it before it gets
Yeah.
behind.
Okay, Ronnie, do you have any new business?
I do not.
Okay, great. Motion to adjourn?
Yeah, sure.
Okay, motion and I'll second. And thank you all very, very much.